Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific time. And we talk about all things related to trusts, estates, probates, both from an estate planning and administration standpoint, whether you're planning your own, doing your own estate planning, or whether you're a professional like me who helps people in the planning and administration of their estates. And so today I'm going to talk about an issue that I think a lot of people care about, and is somewhat opaque. And so hopefully this will give you a sense of how this works. And that is, what does it cost to administrate a probate? Okay, now I'm going to be talking about specifically about a probate, which this will exclude trusts per se. Okay, and that's because when it comes to the costs of administrating trusts, a trust is a private agreement. So generally speaking, the state in which the trust is formed doesn't have a hand in how that trust is administrated. So I've served both as a paid and as an unpaid trustee of a trust. Okay, and that typically is dictated by the terms of the trust itself. So if you if you have a trust, or if you're contemplating having a trust drawn up, so one of the issues you'll need to decide is who is going to be, or who are going to be, my trustees, and are they going to be compensated? Okay, now, if you choose a trust company or a professional fiduciary like me, so then compensation will be an issue, and that's something you'll want to check on in advance before you work that out in your trust. With respect to a probate, whether it's the probating of a will or whether the person dies intestate, and so it's a an intestate administration. The probate laws in each particular state will define how much the administrator will get compensated. Okay, now I'm going to go through an example of a couple of states where I have administrated probates, and you'll see they're very different. And then we'll come back and I'll talk about some additional issues that play into the cost of probating, or of administrating a probate. Okay, so let's see. First of all, we're going to take a look at we'll take a look at Alabama first. Okay, so this happens to be, I just found this on a website of this fellow Brenton C. McWilliams. I've never met Mr. McWilliams, but I happen to know what the law is in Alabama because, like I said, I administrated a probate there. Okay, so you see here in Alabama, by statute, the maximum compensation for an executor or administrator, otherwise known as a personal representative of an estate, in ordinary cases is 2.5% of the value of the estate property received by the executor or administrator, and 2.5% of the value of the disbursements from the estate. Okay, and then within this maximum amount, the executor or administrator is entitled to reasonable compensation for services based on consideration of fairness, including the following. We'll talk about those factors in a minute. Now, you might say, well, wait a minute, isn't that just 5% of the value of the assets in the estate? And the answer is maybe. Okay, so if the estate, if there's no expenses in administrating the estate, then the value of the assets coming in and those being distributed are going to be, for all intents and purposes, the same. Having said that, it would be very unusual for there to literally be no expenses to the estate for going through administration. First of all, there's going to be some legal fees. Okay, so the lawyer will have to be paid for filing the probate action. Secondly, even if the administrator, even if the administrator is working for free, that administrator will probably have some expenses. So unless the administrator is going to absorb the expenses of administrating the estate, as you know, as well as not get paid, it would be unusual for the assets distributed to be the same as the assets come in. Now, if the heir, and let's say you have an estate where there's one heir, okay, and that heir is the executor or the administrator. So then, to a certain extent, it doesn't really matter. He probably doesn't care about reimbursing himself. He's getting all the money anyway. Okay, and if that heir happens to be a lawyer, who knows probate, so then in theory, it's going to be 5% of the value of the estate. But again, he's probably not going to charge that because he's getting all of them. He's getting all of it anyway, and so then it doesn't really make any difference. So while you will hear people talk about the cost of administrating an estate in Alabama is 5%, that's not really correct, because almost inevitably the value of the assets being dispersed from the estate is going to be different than the value of the assets that were received into it. By the way, over time, the value of the assets could have increased or declined even if there were no expenses to the estate, and so that could cause a difference in value as well. Okay, so that's how the fees are figured in Alabama. Now let's look at some of these factors. It says a personal representative is entitled to reasonable compensation for services as may appear to the court to be fair, considering such factors that include or not limited to novelty and difficulty of the administrative process. So if it's a difficult estate to manage, an estate like that is more likely to get the maximum amount. Okay, the skill required to perform the services. Okay. The likelihood that acceptance of the role to administrate the estate will preclude other employment, i.e., can I do this? Can the administrator do it in their spare time, or is this something that's going to be full time? The fee customarily charged in the locality for similar services. Okay, the amount involved and the results obtained. Requirements imposed by circumstances and condition of the estate. So, for example, an intestate administration may be entitled to a higher fee than the same estate if a will had been left behind, because when somebody dies intestate, typically that would indicate that there's been little, if any, estate planning, and so it may be much more difficult to find all the assets, deal with all the creditors, et cetera, et cetera, et cetera. Okay. The nature and length of the professional relationship with the decedent. Okay, the experience, reputation, diligence, and ability of the person, the liability, financial or otherwise, of the personal representative, and the risk and responsibility involved. Okay, so the court will take into account all of those factors, plus there may be some other factors that they're taking care of. So they cite a case here. I think this is Well versus Bradley. So the estate received over $40 million worth of assets, and the administrator was compensated less than $2 million. So you can see that's 2%. That's not 2.5%. Okay, and the assets distributed were a little bit less than what was received, okay, and yet the compensation went up, okay, to a little bit over 2%, okay. So the estate was very large and complex. The estate was valued at more than $35 million at the time of Wells' death. Okay, and it included some unusual assets, competition-trained hunting dogs, partial ownership interests in thoroughbred horse, et cetera, et cetera. So you can see there's all kinds of difficulties there, okay, that made the total fees right about $4 million. Okay. Da, 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 da. I'm sorry. I gave I gave not I'm sorry, not 2%. They were 5%. Okay, so this was such a complicated estate that the total um, uh, um, okay. Oh, I'm sorry. Right. So the total compensation was almost the maximum. I'm sorry, I gave you the facts wrong. The total the court could have approved was a little over $2 million. They approved a little bit less than $2 million, but close to the what would have been the 5%. Maximum, or the 2.5% of this and 2.5% of that. Okay, so and it was because of all these complications here. Okay, so that's Alabama. Okay, now we're going to look at next at California. Da, 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 da. Here we go. How much does probate cost? Okay, all right. So this is a website called Smart Asset. Okay, now in California, they have a statutory fee schedule as well. And you'll notice it outlines the compensation for executors, personal representatives, and attorneys. Okay, and it's a graduated schedule. So the first $100,000 of value to the estate, the probate fee is 4%. The next 100,000, 3%. The next 800,000, 2%. So if an estate has $1 million in assets, the fee is going to be 4,000 plus 3,000 is 7,000 plus 16,000 is $23,000. So it's going to be a 2.3% fee on the first $1 million. Now, notice, by the way, that's significantly less than what you would get if this estate were in Alabama. Now, the next $9 million is a 1% fee. So 1% of $9 million, $90,000 plus 23, $113,000 on a $10 million estate. We're at a 1.1% fee, much, much lower than Alabama. And then a 0.5% for the next $15 million, and then above $25 million, the court determines the fee. So you can see that the fees in California are significantly lower. Having said that, okay, the court can award extraordinary fees if and they can be awarded for performing tasks outside of the norm. Okay, they could include managing a business that belonged to the decedent, contested wills requiring litigation, complex legal disputes. Okay, other issues may involve addressing environmental issues in real property, resolving complicated tax matters of the estate. Okay, so in this case, you can see the conditions aren't necessarily the same, although I would bet if you showed a judge in California the list from Alabama, the California judge would go, yeah, these are the kind of things we take into account in terms of extraordinary fees. Okay, so you can see, but very different fee structures. So the first thing about determining now, by the way, you noticed in Alabama, the fee was for personal representatives and executors. Here, it's also for attorneys. Okay, but it's not that the attorney and the personal representative share. It's that the same schedule applies to each one. So in essence, the attorney, for a $1 million estate, the attorneys can charge up to $23,000, and the personal representative or executor could also charge $23,000. And then if there were extraordinary issues, they could get even more than that. Okay, so in other states, the fees will be according to their fee schedule. So if you live in I don't know, Colorado, so the thing you need to do is to do a search, and the search I use is just the name of the state, probate administrator fees. Okay, and you will probably get the answer to your question real quickly. Okay, so in fact, let's just do an example here. Here we go. I'm going to really go out on a limb here. And let's go back to this, and let's just do here. I was talking about Colorado, so Colorado probate. Oops. Probate administrator fees. Okay. Okay. What are the probate fees in Colorado? Okay. Well, that's just for filing. Let's see. Let's scroll down here. Okay. Cost of probate. Okay. So here you go. Here's a website. Cost of probate in Colorado. This is done a couple of years ago, and I thought I saw it here. Yeah, the Boulder County Area Agency on Aging. I don't know why this is coming up. How do I get no thanks? Okay, often amount to 5% of the estate's total worth. Okay, now that they're not saying, by the way, that that's the statutory limit. Okay, but they're saying that's about what it is. So similar in Colorado to what it would be in Alabama. Okay, all right, and so that's what that's what you'll do to get an idea of what probate administration fees should be. Now, here's the thing: in a state like California, where we have this role called a licensed professional fiduciary. So we are required by law to disclose our fees on our website. Okay. And so if you go to my website, in fact, here we'll go ahead and share my screen once more. We'll go to my website. Here it is. Okay. Share. All right. So here's divisions and services. Oops. Click. Here you go. Bemmel Group fee schedule. Okay, and there it is. So here's my fee schedule. So if you want to know what it costs to hire me to administrate an estate, here's what it is. It's all right here. Okay. Now you say, well, wait a minute. How come you have all these fees and such here when California has a statutory fee schedule? Okay. And the reason is that, first of all, I administrate trusts. And so if you have a trust, the fee schedule doesn't apply. And so you may want to know, okay, what does it cost? And the second thing is, if the heirs consent to it, generally speaking, the court will consent to a fee schedule even in a probate. Okay, so I'm working on a case right now where the heir has agreed to my fee schedule. Okay, so when I apply to the court for fees, generally speaking, when the probate is concluded, so I'll submit my invoices based on my fee schedule, and the court, assuming the heir doesn't object, which the heirs, I should say, don't object, which they probably won't. So then I'll get my regular fee schedule, and that is typical even in a state like California, where the consumer laws are very, very strict and all of that kind of stuff. Now, if not, the reality is, as you saw, because in the fee schedules, when there's extraordinary circumstances, okay, the fees can be higher than the statutory minimums, and so I can also apply for higher fees based on the actual work that I'm doing. Okay, and that isn't only for professional fiduciaries. That's for any executor or any personal representative. So in California, for example, you notice one of the issues was, are you having to run a business as part of the administration of the estate? And does the running of that business take special skills? So if that's the case, you have a claim to say I'm entitled to more than the statutory fees because I'm doing this whole other thing that takes all this additional time. Okay, so that's really where the so-called rubber meets the road. Okay, and I want to emphasize that you do not need to be a professional fiduciary to be an executor or an administrator in California. You only need to have the license if you're going to be the executor or administrator for 2 or more estates at the same time. That's when the license requirement kicks in. So I don't mean to imply that you can't be an executor. You certainly can. But if you are an executor, whether you're a professional fiduciary or not, the fee schedule does apply, and so you're going to want to know the rules. Conversely, if you're an heir and you're not an executor or a personal representative, so then you want to know, hey, what is the estate going to have to pay? Okay, and you're going to want to look that up. Okay, like I said, in California, where you have professional fiduciaries who are required to disclose their fees on their license on their website, so you can get fee information. In other states, that is not required, and you won't necessarily find that information. But if you were to talk to an attorney who specialized in probate, they should be able to give you an idea of what it would cost to probate a particular sized estate. Okay, and so that's the key. Now, why is this all important? Well, I mean, the fees for administrating the estate are going to come out of the assets of the estate. So while I'm not suggesting you necessarily want to choose an executor or a personal representative based on their fees, you obviously you want someone who's competent. But if 2 people are equally competent, so then there's no reason to pay more fees. And so, and number one, and number two, fees are, you may be able to negotiate fees. And so that can save some of the expense to the estate. So I have a friend here in California, and his goal is to develop a system whereby a typical estate can be administrated in half of the usual time, or well, he says twice as fast for half the cost. So I may have mentioned Josh in a previous episode. And you'll notice if he can do it twice as fast for half the cost, he's still in essence getting the same fee on an hourly basis, if you will. But the estate itself is saving, quite a bit of money. Now he's generally dealing with, smaller estates, $1, $2, $3 million estates, okay, and ones that are not particularly complex. And so, and so working on developing, sort of economies of scale and standardized practices and those kind of things, and that's good, right? So for that kind of estate, the more that can be routinized, the faster they can be done, and that's good for everybody. It's good for the heirs because they'll get their money much more quickly. It's good for the courts because things can move through the court more efficiently. And it's good for the administrator or the personal representative, the person acting in that role, because they can handle a lot more clients, okay, and do so much more efficiently. And hopefully by doing so, do better financially. So all of these things should be kept in mind. There are good things to ask questions about as you're doing your estate planning. If you're an heir, there are good questions to ask at the beginning of the administration of the estate. so that people can really understand what's going to be involved, what it's going to cost. Okay. And so that there's not a lot of dissension when it comes time to close the probate, which that's when administration gets expensive, when there's disputes and now there's litigation and all that kind of stuff. So um, that it's a very good idea to check all of this stuff out in advance, or at least in the beginning of the probating of an estate, to make sure that everyone is as clear on these issues as can possibly be. So that's our show for today. Thank you very much for joining me. And tomorrow at 10 a.m. is my show, Business Lessons from the Military. And in honor of today being Memorial Day, tomorrow I'm going to be talking about the 3 holidays honoring military people. So I don't know about you, but I was scrolling through my Instagram feed this morning, and I saw a number of messages about Memorial Day. And I would say most of them, either the person doesn't really know what Memorial Day is about, or they were making it different than it was for another reason. And so I'm going to be talking about that tomorrow. And you say, well, what does that have to do with business in the United States or business in general? And tune in tomorrow at 10 a.m. Pacific time, and you will find out. And then on Wednesday at 10 a.m. Pacific time is my show, People Making Money. So look forward to seeing you again later this week. And thank you very much again for joining me. Hope you enjoyed it. If you have any questions or comments, please feel free to drop them into social media or send me an email. The links will all be in the show notes after the episode posts. Happy to respond to them. And wrapping up, as I always do, signing off. Marie, you're my belle. All the best, folks.